Never confess who you are. Never walk into a police station or court voluntarily. If you do, you traverse and acknowledge the validity of their jurisdiction/offer. As Lao Tzu noted 25 years ago, do not invite the fight, accept it instead. Better a foot behind than an inch too far ahead. Let the offer come to you, don't make the offer. When you're confronted with an obligatory court appearance, keep in mind the following. Everything is commerce contract being administered in a state of emergency under the war powers. The Commerce Clause of the Constitution operates in the private international law merchant of the bankers to whom essentially every government in the world is bankrupt. All of this functions in Admiralty Maritime, where you have no rights and the captain's word is law. That's why if you're charged, you're guilty. And it doesn't mean you did anything, it just means that you're going to pay. All crimes are commercial, they have a monetary value attached to them. As a result of the above condition, military war powers enforce all interstate commerce, which is everything, with draconian penalties for impeding commerce. Because the climate in which we live is a relentless and ravenous assault from all aspects of the government against our commercial liability, i.e. revenue raising, enforced by guns, violence, and prisons, life in America is a high-risk venture. It requires understanding and how to neutralize the endless barrage of attacks in the form of commercial presentments and offers. Fighting is a no-win proposition. Matters must be neutralized, defused, and transmuted into victory without conflict. We have no money, only private debt paper, insurance script. It's like monopoly money or casino chips, which a real monopoly was foisted on the world, operating in the bankruptcy. Everything is commerce, which is banking, which is debt paper, which is credit, debit balances on bank books, which is bookkeeping. Assets or credits must always equal liabilities or debits. The books must always balance for world commerce to operate. The commercial accounts must be cleared within 3 business days, which is codified in the U.S. in the Federal Truth in Lending Act, Title 12 U.S.C. 1601, Regulation Z. A traffic citation, summons, indictment, complaint, etc., is a commercial presentment. When the presentment is issued, a debt is created, a liability on the bank's books, which must be balanced with an asset. They want you to supply the asset in the form of paying a fine or some specific performance or jail time. If you can't pay or you refuse to pay, whatever the bail amount is, they issue bonds based on that amount and they sell those in the equities market. Say you have a $1 million charge and you go into court and you say, yes, I understand the charge, and you plead not guilty. Immediately you're in contempt. They issue the bonds, they sell them, and through the actuary tables, they work out how much time it's going to take for that bond to recoup the amount, the $1 million, minus whatever their cut is. And that's how long you'll sit in the warehouse. So it's not just arbitrary amounts of time. And these prison bonds, bid bond, performance bond, payment bond, they're all issued based on the charge and sold on the international debt market as mortgage-backed securities. Are what funds everything in this country. That's why there's more people in prison today than any other country in the world. So you can deny or fight the charge and thereby traverse and join the action, legitimize their cause of action, and lock yourself into their jurisdiction. This is a commercial dishonor. If you enter a plea or the judge enters one for you, you have traversed. The only issue now is the facts. Did you or did you not run the red light? In other words, dishonor submits you to a court proceeding to resolve the dispute over the facts of the matter. You can demur. A demurrer accepts all charges, facts as true, and raises of issues of law. A classic example is, yes, I did it, but so what? The statute of limitations has expired, so issues of law, foreclosure, all possibility for me to be prosecuted in this manner. The next thing you can do is you can stand mute, in which both the law and the facts are invoked. The judge will enter a plea for you, and the court proceedings to resolve the controversy will commence. Standing mute is also a commercial dishonor and locks you into both law and facts. You can protest, such as denying jurisdiction. This also locks you into a requirement to proceed with the court process to resolve the dispute. And number 5, you can accept the offer of the charges, citation, summons, complaint, indictment, etc. for value. Of the above option, only number 5 diffuses or dissolves a controversy, thereby obviating all the necessity or possibility for court proceedings, since there is no dispute to resolve. You have agreed with your adversary quickly while you are in the way with him. Makes you the owner of the contract or offer. Makes you the creditor. The creditor is always the winner in court proceedings, all of which have only 2 classes of participants, creditors and debtors. Debtor always loses and pays. After you accept for value and own the contract offer, the matter is non-negotiable, i.e. private and personal between you and the offerer in his non-official capacity. Every arrest and incarceration today is seizing the surety on a commercial dishonor. The commercial accounts must balance for commerce to function. It is not possible to retain only the debit side of the bank ledger. The offsetting asset side must be there for the books to balance, the commercial account to clear. Otherwise, world commerce would collapse into a pile of mush immediately. When you dishonor a commercial presentment, citation, etc., the offerer accepts your dishonor, undertaking banker's acceptance and executing a bill of exchange. This bill of exchange is for at least 10 times the face amount and possibly 100 times. The one who accepts, being the creditor, is entitled to place whatever value he wishes on the transaction. The counties run these bonds. You must now pay the full amount of the bill of exchange, the bond, or the account remains open indefinitely. The books never closes. If you fail to pay in Federal Reserve notes to balance the books, then you are arrested and incarcerated as a surety collateral to raise the funds to balance the ledger. These funds are raised by borrowing via your straw man on the public debt for which you, the real being, are responsible for paying, discharging, if you have not rebutted the rebuttable presumption that the king, the wizard, the bankers, the power elite, etc., owns all capital letter name, owns your all capital letter name. You have no liability if the books are fully balanced. Performance on acceptance balances the books. This is one reason the prisons are so full. Another reason is that the judges are part owners of the prisons and make money on everyone they incarcerate. Prisons are immense money-making operations due to the bonds raised against the straw man debtors of the people, the collateral warehouse behind bars. High dollar amounts are attached to the bonds raised to incarcerate people. The prison industry is big business, constituting the major industry in California, Texas, and Florida. This is what they're trying to do with the whole world. They're trying to put everybody in prison. This is the scheme. And that's what they're doing. Under the guise of a so-called virus, a corona. If you have a bail bond, you can't proceed until you rid yourself of the bond. Accept it for value, send it back to the bondsman, register the bond in the commercial registry as your secured party. Never confess who you are. That is bearing false witness against yourself. Some people advocate carrying no identification. If you are arrested, they have 2 hours to identify you. If you identify yourself, they're allowed to hold you, provided you don't sign their paperwork or otherwise traverse for 3 days, 72 hours. Regulation Z, truth in lending. The general rule is therefore, of course, never tell them who you are. Why do their job for them or sign anything? Anything you do except comply insofar as dealing with the police is concerned is interfering with the policeman in his line of duty. What is his duty? It is revenue collection for the city. One of the 3 things needed to identify you: your date of birth, the day your vessel, i.e. body, was birthed into the 14th Amendment public charitable sus decay trust as a citizen of the United States, a corporate franchise launched into a voyage in commerce in an ocean of insolvency, i.e. unpayable bankruptcy. Number 2 is your driver's license. Number 3 is your social security number. Without any of the above three items, their job is difficult to impossible, especially with a 2-hour time limit. Now you know why they want to chip in you. A judge's job is to get you to traverse consent and dishonor and thereby make an offer which the judge can accept and thereby own. If you are hauled into court or forced to go under threat, do not offer and do not negotiate. If you reject, negotiate, or issue a counteroffer, you create a controversy. You perform a dishonor in which the judge can accept. Concerning every offer a judge makes to you, accept it for value with the words such as, "Thank you for your offer, which I accept for value. May I have your name, please?" You are acknowledging that his commercial presentment and that you are acknowledging his commercial presentment and wanting to know with whom you are doing business and entering into contract with. Thereafter, you must proceed with the remainder of the standard question and request, i.e., do you have a claim against me? Do you know anyone that has a claim against me? I request the order of the court to be released to me immediately. If the judge says, "I don't have a claim against you, but I believe that the prosecutor does," you proceed with the 3 questions to the prosecutor. If he says that the state of California, United States, Inc. has a claim against you, say, "I call the state of California to the witness stand." There has to be an injured party, because it's all commercial, it's all civil. When the state of California fails to take the stand to testify, to be cross-examined, you can say, "It appears that no one has a claim against me. I request the order of the court to be released to me immediately." Remember that when you accept their offer for value, you place the amount on the transaction, and they're required to perform and adjust your account. You are now the secured party, i.e. creditor. You are the principal, and the interest goes to you. The central core of any dispute is whom can state the claim upon which relief can be granted. Whoever can prove his claim wins. See, there's no money to pay anything with. It's all just commercial credits and debits. And you and I are the creditors for this bankrupt corporation called the United States. And they're trying to get us into controversy, when all you need to do is say, "Just show me the paper and I'll pay it. I accept it. Where would you like me to sign? I want to effect payment immediately. Accept it for value. Here's my IEN number." Without rebutting their rebuttable presumption by filing a UCC1, their unrebutted presumption stands as truth in commerce, and you have no standing in law. You are bereft of rights, devoid of standing in law, and completely unable to state a claim upon which relief can be granted. The result is you are rendered permanent debtor owned by them, and concerning which they have a carte blanche to deal as they wish. You are a slave on the master's slave plantation without capacity to go against your owner. Once filing a UCC1 financing statement, you have irrefutable proof that you are supreme claim, and if you proceed correctly, win in any proceeding as the acknowledged creditor in the matter. When all would-be claimants lose for failure to state a claim upon which relief can be granted. The bottom line is, therefore, how do you state your claim upon which relief can be granted in a manner that cannot be ignored by a judge or administrative agency? The catch-22 of the matter is that in law, only the original counts. But if you surrender your originals of something, you no longer have it. Then if the opposition confiscates it, you are devoid of a way to prove you have a claim to lose. The conundrum is resolved in the following manner. Obtain certified true copies of your UCC filings in the commercial registry that establish your basic claim on your straw man, and also any particular matter at hand, citation, indictment, court case, etc. Take the above referenced documents plus a certified true copy of the court docket sheet signed, dated, and stamped by the clerk pertaining to your case, if one exists, to a notary and have 2 or more notarial acknowledgements of the entire package as a certified true copy of the original. Sort of one of the original notary acknowledgements via process server or means such as registered mail with affidavit of service executed by a third party notarized on the judge, designated the name of judge, upper and lowercase spelling, doing business as name of judge, full all caps, full name of court, all caps, if such exists, or the legal department or party office that receives service of process, reference an agency. A notary acknowledgement has a powerful effect and ramifications. It must be entered as evidence on the record of a court case, and the judge must take judicial notice of it. To achieve either of these results is not always easy. By proceeding in this manner, you have placed before the judge or authorized party on other side a proof of your supreme claim that must be recognized and cannot be avoided. In short, you have stated on the record, court or administrative, proof of your claim upon which relief can be granted. All right, I'll leave the link to this article down below. Go to stopthepirates.blogspot.com. Thanks.